Hey class, it's Mr. Stewart. Welcome back to our integrity video series here in CRJ 130. And this week I'm going to be talking about Chapter 10, which is how civil cases begin. Now, the last chapter that you read, we didn't have integrity video last class, but the last class you read was about the trial courts and how criminal cases end. And the trial courts are fairly straightforward as far as how a case basically moves through the system. And if anybody has any questions or issues with that, please reach out and I'll be happy to answer those questions. But we also need to consider civil cases, because sometimes a criminal case becomes a civil case. Sometimes a civil case also becomes a criminal case. A good example would be the O.J. Simpson murder trial. O.J. was tried for the murder of his wife and her friend, and he was found not guilty of both of those. But then Nicole's family and I can't remember the other guy's name right off the top of my head, but her friend Ron, I believe his name, Ron Goldman. Nicole and Ron's family sued O.J. for wrongful death in civil court and were able to win that lawsuit, effectively driving O.J. Simpson into bankruptcy because it was a very large decision. And that's one of the keys to understanding the difference between the criminal and civil process. Remember, with the criminal process, you have a much higher standard of proof. That's proof beyond a reasonable doubt. And if you were to try to put a numerical score on that, you're talking about better than 90% surety that the person engaged in the criminal act. However, with a civil case, all you really have to do is simply tip the scales toward one side or the other. And that's really all that's required. That's called a preponderance of the evidence. That is the standard or quantum of proof necessary in a civil case. It's just tipping the scales toward one side or the other. And also understand that with civil cases, you don't get punishment, you get damages. You also do not go to jail for violations of civil law. And basically, a civil case is simply where one person has wronged another person, or one person has wronged an entity or group, or an entity or group has wronged a person, and they're just trying to get damages for the harm that was caused through that wrong. For example, if I were to sell you a used car, and I tell you this is the best car ever, and I warranty that car for 30 days, and you get down the road and the engine falls out onto the highway 6 days into your purchase of this used car, and you come to me and say you had a 30-day warranty, and I say that's too bad, so sad. I'm not gonna honor that. You bought it as is. I was just blowing smoke, to get you to buy the car, and so they sue me. I wouldn't go to jail for that, but if the court found for the party that sued me, that's called the plaintiff. The person who is doing the suing is the plaintiff, and I would be the defendant. If the court found in favor of the plaintiff, then I would have to pay damages, probably the value of the car, as well as maybe any pain and suffering or mental anguish caused, or any other harm caused, such as a tow bill or a taxi ride, or a rental car fee, because the car had broken down. Now that doesn't mean that I'm going to win, that I or the plaintiff is going to win a lawsuit. Honestly, it can go either way. It just depends on which side presents the best evidence and probably has the most credible witnesses. So understand that this civil cases begin through a grievance. And if you look on page 291 in your textbook, there's a pretty good little table there at the bottom of the page. It says that for every 1,000 people that have a grievance against somebody or some group, only about 718 of them file a claim. And then out of those 718 that file a claim, you have about a little bit more than half will actually dispute the claim, and that means that the other party is saying, oh no, I'm not responsible for that, so therefore we're going to fight this. And then out of those 449 that dispute the claim. Only about 100, just a hair over 100, actually hire a lawyer, and about 50 of those 100 actually decide to go forward with an actual court case and a lawsuit. So you can see that it's actually fairly small number of people that actually file a lawsuit versus a number of people that have some sort of grievance with somebody. This is very similar to a model that we see with the criminal side, that for about every 1,000 crimes that are committed, only about 25 to 30 people go to prison. And basically what that means is that, only half of the cases are reported or thereabouts, and then it just begins to dwindle down from there as the case moves through the system. So, it's actually very hard to go to prison here in the United States. The odds are in your favor that you probably would not go to prison unless you really did a very severe crime. And same way with civil cases, the odds are that your grievance would actually end up in a valid lawsuit are fairly small. So basically, people try to sue people anytime for any reason, and the courts try to weed through those because a lot of them are very frivolous lawsuits. They have a grievance, and then they file a claim, and then maybe that's where it stops, or maybe they just have a grievance and they don't do anything about it. Some people don't. Some people just have a grievance and decide there's nothing that can be done, so therefore they don't. So really what we're worried about for the rest of this chapter are those 50 out of 1,000 people that have grievances, those 50 that actually decide to sue. And make sure you read in the textbook these particular terms in regard to the civil cases, what grieving means, claiming, disputing, hiring a lawyer, and then actually filing the lawsuit. There's another table on page 292 that really explains this very well. And also understand that many of these cases may even be resolved without ever hiring a lawyer. It simply is you file a claim, and the person begins to dispute that claim, and then you kind of stay on their back, and then finally they say, okay, we'll take care of that. I mean, that happens a lot of times with auto insurance. Maybe somebody hits you, and let's say that the other person's insurance says, yeah, you filed a claim with us because our customer hit you, but we're not going to pay that, or we're not going to pay as much as you want. And so you end up having a dispute. Just because a dispute exists doesn't mean that it's going to end up in a lawsuit. It simply may mean that it's time to negotiate. And a lot of these cases are resolved through negotiation and through a give and take process, because I can guarantee you that most entities and businesses, if somebody files a claim and they dispute it, they will probably eventually settle with something, because they don't want to go through a trial process, because trials are expensive. Either party typically has to have an attorney. The attorney's charging you through the nose per hour, and therefore many of them will just settle out of court. Even if they don't believe that they did anything wrong, it's cheaper for them to pay you some money, and you go away than it is to try to take this thing out through a court system that may last a long time. So there are a lot of resolutions that happen without ever filing a lawsuit. Now that doesn't mean that we don't have a lot of lawsuits in this country. I mean, we have a huge problem with frivolous lawsuits, and some things actually get to the point of going to trial, and they probably never should. I was aware of an incident that happened one time with somebody that I know who got cut off in traffic, and this person that I know actually flipped the bird to the other person, and the other person got her tag number and sued her for flipping her off. And it went to court, and the judge says, "Are you kidding me? You're here because somebody is suing you because you flipped them off? Where's this country getting to? And he dismissed the case. I mean, he's like, there's no reason this goes any further than this. This is stupid. And you'll see that people will file a lawsuit for anything at any time. And it may be frivolous, it may not be, but there's a lot of lawsuits that are filed, and many of them that are filed are what I would consider to be frivolous. So, in your book on page 296, it talks about why we have an increase in the amount of civil lawsuits, and in 297 it even goes into, talks about the shifts in the business and the political institutions. And we are in what I would consider to be a sue-happy society right now. That's what we do. If somebody wrongs us, or we think that they have wronged us, we simply just file a lawsuit and sue them. That's something that just didn't happen that much in years previous. I mean, and it's pretty interesting because people will get offended, and then they'll sue the person that offended them instead of putting on their big boy or their big girl pants and just sucking it up and going on, which is what we have done in years past. And so what that's really led us to in the civil system is a movement towards something called tort reform. And at this point, you ought to know what the term tort is, T-O-R-T. A tort is simply a civil wrong. In the criminal realm, we would call it a crime. In the civil realm, we call it a tort. And so there's been a movement toward tort reform in the last several years to try to reduce the amount of frivolous lawsuits that are filed so that the courts aren't burdened so much and just bogged down with all of these lawsuits that really just move partially through the system and then get dismissed, or interest is lost, and they're dismissed on behalf of the plaintiff as well. So just understand that there has been a movement toward tort reform, and it's a necessary movement in order to free up the court systems to actually handle the cases that the courts need to hear. I mean, people do defraud people. People do engage in wrongs against other people, and there are a lot of lawsuits that are filed that are perfectly legitimate, and the person needs some sort of damages awarded. I actually served on a jury. I think it's probably around 2009, I believe, on a civil case when I was living out in Colorado, where a doctor had misdiagnosed a person, not just one occasion, but had actually seen the guy 3 times and had misdiagnosed or missed the problem that was causing the guy's pain, and the guy ended up dying. His aorta was actually coming apart at 40 years of age, and he was experiencing some fairly severe pain, and the doctor thought it was gastritis, but the doctor would not order a particular test because the guy didn't have insurance, and he didn't want to get the doctor said on the stand he didn't want to get the hospital stuck with paying a big bill for an expensive test because the guy didn't have insurance, so he did not therefore order the test. The guy died. His wife sued. They had 2 middle school and high school age children, and they ended up getting enough money basically so that the wife can live comfortably from now on, and the kids both get their college paid for. Now, the doctor's malpractice insurance actually paid for the lawsuit, but as part of the court process as well, because the doctor had engaged in substandard medical care, they pulled his medical license for a time. And the last thing I knew, he was working at a dollar store, which I thought was kind of interesting. This guy was a doctor, and he had to work at a dollar store, to pay his bills until he could get his medical license back and probably move somewhere else and go back into medical practice again. So, that was a very valid lawsuit. And I felt sorry for the guy's family because, the guy was 40 years old. He's younger than I am at this point. And basically keeled over in his recliner because he had went to the doctor, and the doctor gave him substandard care and couldn't find out what the problem was, and of course he paid the price for it. Really didn't even know what hit him when his aorta finally burst open. he lost conscious immediately, and there was nothing that they could do for him. He was dead. So that's a really good example of a civil case that is valid and needed to be heard in the court. As a police officer, I've been sued in civil court multiple times for over $200 million, and I've never lost a lawsuit because they've all been frivolous. There was no grounds for that suit, but yet it didn't stop the person from filing the lawsuit. It took court intervention to say, that's enough of this. We're not going to go forward with this because this suit makes no sense. It has no grounds. So what tort reform is supposed to do is to keep a lot of those types of cases from ever getting into the court system. Now, typically in a civil case, you get two types of damages that can be paid. You will get what's called compensatory damages, and that actually compensates the person for the actual harm that they have suffered. For example, if let's say that I hit somebody with a baseball bat and broke their nose and cut their face open, and they incurred some medical bills, let's say even plastic surgery bills to rebuild their face. If they sued me in civil court, they would probably win, and I would be responsible for paying them compensatory damages for the actual loss that they occurred, i.e. the medical bills. I may also be responsible for, as part of that, maybe the missed work, or in anything that actually costs them financial losses or hardship. I'd be responsible. That's also part of compensatory damages. Many juries will also award the winner in a civil case punitive damages as well. And what punitive damages are, those are damages that are saying that you're going to pay for the actual losses, but we're going to make you pay more because this is something you should not have done. And so we're going to compensate the winner in the case for their pain, their suffering, their mental anguish. We're just going to give them more money because your actions were grossly negligent. This is above and beyond those compensatory damages, and it's designed not only to punish the defendant but also to deter others from doing the same thing. It's one of those things that it's kind of like a big fine in a criminal case where the fine is part of the punishment. If we fine you a lot of money, then that's supposed to be a deterrent that you shouldn't do this again, and it's also a deterrent to everybody else that, hey, if I get caught doing this, then they're gonna make me pay a whole lot of money. Well, in civil court, because it's not criminal, we can't really consider it punishment because we don't punish in civil court, but it's based upon your gross negligence and whatever the action that you did caused whatever damage that you caused, and hopefully that makes sense to you. Please read over in your chapter on 303, state level tort reform, and 304, national tort reform. And I want you to understand that there are basically two realms of civil cases. There are what we call routine or simple civil cases, what you might call small claims court. And each state kind of puts a limit on the damages that you could get and the types of losses that you would incur that would allow a case to be filed in small claims court. And then you also have what we call high stakes litigation or very complex tort cases or civil cases in which we're seeking a whole bunch of money. This is typically your medical malpractice cases. Where millions of dollars are asked for. These are maybe you have an unsafe work environment. Maybe a medication caused harm to somebody. Your book talks about a medicine called Vioxx and how that caused harm to a whole bunch of people. These class action lawsuits where a whole bunch of people join in and they get these huge settlements those are very complex cases, and those attorneys that file those make a lot of money. They typically will get 40-50%, if not even more, of the actual judgment rendered. So if the plaintiff or the defendant, whoever wins, actually has to pay, then the attorneys are pocketing a whole lot of money, and that's why people have problems with attorneys a lot of times, because of the amount of money they charge. But it takes a lot of work to take one of those complex civil cases to fruition. It's not something they can just show up and do. There's a lot of work. There's depositions. There's background investigations. There's a lot of paperwork. There's preparing for what the other person's going to do or say. So it is a whole lot of work. Understand that not every civil case also ends up going to a trial. Sometimes we go through, as a spouse in your textbook on 309, alternative dispute resolution, where we call that maybe arbitration, where you get together with a person and you try to play let's make a deal, basically. So this thing doesn't have to go to court. Your book also talks about some of those examples of alternative dispute resolution, such as community courts, arbitration, settlement funds. Maybe you simply you file a claim on a case that's already been settled, and there's money in the bank for future plaintiffs. So you just file it, they look at it, and they say, yep, you're eligible for that, and they send you some money. I've seen that happen before too. So there are definitely ways that you can obtain damages even without having to go to trial. There are lots of ways that you can resolve the cases without going to trial. Make sure you read this chapter very well. It has quite a bit of information in it, and basically I've kind of given you an overview of the civil process. The ins and outs are in the chapter, and so you do need to read that chapter. But I'll be happy to answer any questions you guys have, and I'll see you next week for another integrity video. Have a great week, guys. I'll see you in discussions, and I will be getting grading done over the next few days. Bye-bye.